Good morning, Council.
May it please this honorable court, your lordship, I kindly call upon constitutional cases 007 of 2023, 009 of 2023, Mofomobe and Shale versus the PF.
May it please honor court, my lordship. I appear alongside advocate, the supreme, and the permitter for the applicant. May it please you, my lord, I am advocate Jamie Wu, standing in for advocate Mshweshwe from the case.
Thank you. Council. The judgment runs into 47 pages and 80 to 81 paragraphs. So I don't intend to read the whole judgment. What I'm going to read is just the introduction. From there, I'll jump to paragraph 47, where I'll speak to the validity of the warrants. This judgment is prefaced with the following quotations. Quote, one of the main arguments put forward by the editors in favor of a conclusion that would permit the press to report unauthorized disclosures about the security services was the so-called unaccountability of the security services. But the security services are not unaccountable. They are accountable to ministers of the Crown, who in turn, through the ballot box, are accountable to the public. MI5 is accountable to the Home Secretary and to the Prime Minister. The Prime Minister is the leader of a democratically elected government. The editor's complaints of unaccountability come to no more than that, in their view, the Home Secretary and the Prime Minister do not exercise a sufficiently close control, and that they desire ministerial control to be more openly exercised. These are matters of legitimate public debate, but they do not, in my opinion, create any legitimate public interest requiring the public disclosure of the operations of the security services. Nor do I think there's any legitimate public interest served by the disclosure of Burgess' activities with Churchill's daughter, unquote. The second quotation reads as follows. As a general policy, governments do not comment on assertions about security or intelligence. True statements will generally go unconfirmed, and false statements will normally go undenied. As a result, and because of the particular credibility attaching to statements about security or intelligence by members of the services concerned, the circulation of misinformation by a member of the services may, in a different way, be as harmful as his disclosure of genuine information, unquote. What is quoted above provides context to the issues raised in the two consolidated cases before us. Safe to say that the main issue in this case is the legal accountability of Lesotho's National Security Service. The consolidation of these cases was necessitated by the identical nature of the causes of action. The applicants in their respective cases, namely Mofomobe in constitutional case number 007 and Shale in constitutional case number 009, were served with executive warrants authorizing the seizure and search of their phones by the National Security Service, NSS, in terms of Section 26 of the National Security Service Act number 11 of 98, herein referred to as the NSS Act. Both warrants were issued on 16 May 2023. On 17 May, officers of the NSS served Mofomobe with a warrant. He refused to accept it and contested its execution, and the officers left. The following day, he filed his constitutional application on grounds of agency. It was moved on 19 May, and a consensual interim order was made suspending the execution of the warrant. On 18 May, the NSS served Shale with a similar warrant. It was executed upon being advised by his lawyer to surrender the phones. His application was filed on 22 May on grounds of agency seeking interim orders for the return of the cell phones and stay of their search. I consider that there was an unjustified delay, but order that his application be heard on the date scheduled for Mofomobe's application on 5 June. The applicants seek the following orders. 1, striking down Section 26 of the NSS Act as unconstitutional. 2, declaring the issuance and execution of the warrants as a contravention of the applicant's constitutional rights to privacy and freedom from arbitrary seizure of property, protected by Section 11 and 17 of the Constitution. 3, reviewing and setting aside of the warrants on the ground that their authorization is legally invalid, cause of suit but sought by Shale only. 5, further and/or alternative relief. It is common cause that the issuance of the impugned warrants is authorized in terms of Section 26, which reads as follows. 26(1), notwithstanding any other law, no entry on or interference with property shall be unlawful if it is authorized by a warrant issued by the minister under this section. 2, the minister may, on an application made by a member of or above the rank of higher intelligence officer, issue a warrant under this section authorizing the taking of such action in respect of any property specified in the warrant as the minister thinks is necessary to be taken to obtain information which A, is likely to be of substantial value in assisting the service to discharge any of its functions, and B, cannot reasonably be obtained by any other means. Subsection 3, 4, and 5 reads as follows respectively. A warrant shall not be issued under this section unless it is signed by the minister or in an urgent case where the minister has expressly authorized its issue and a statement of that effect is endorsed on it, it is signed by the Director General or an officer authorized by the Director General. A warrant shall not be issued under this section unless, if it was signed by the minister at the end of 6 months from the day it was issued, or in any other case at the end of the second working day following the day it was issued. If at any time before the day on which a warrant would cease to have effect, the minister considers it necessary for the warrant to continue to have effect for the purpose for which it was issued, he may renew it in writing for a further period of 6 months. The minister shall cancel a warrant if he is satisfied that the action authorized by it is no longer necessary. The parties are on common ground that the warrants were issued following applications by the Director General of the NSS. The first application reads as follows. It's a memo to the Minister of Defense, National Security and Environment from the Director General. There's a reference number, signature, the name of the director. The heading is re-application in terms of Section 26(2) of the National Security Service Act number 11 of 98. Quote, the above subject matter bears reference. I humbly request that you issue a warrant in terms of Section 26 of the National Security Service Act number 11 of 1998, authorizing the service to seize with immediate effect the mobile phones of and all those in the possession of one Machisetsa Mofomobe, a Mosotho male adult resident at Hatetsane in the district of Maseru. Further authorizing that upon the said seizure, the service conduct an investigation on such mobile phones and make copies of any information contained therein which have a bearing on the functions of the service. Further, that the service retain possession of such mobile phones for a period of 30 working days for the purpose of investigations. The request is premised on the fact that the said Machisetsa Mofomobe is in possession of classified information/material which he received through electronic means without authorization from Intelligence Officer 4, in brackets, 1 full stop 0 full stop 4 close bracket, Pitso, stationed at Maseru NSS. There is further credible information to the effect that IO4 Pitso is not the only NSS member who has sent such classified material to Machisetsa Mofomobe. Therefore, information obtained from the cell phones shall reveal such members. Further, that there is information therein which implicates his involvement in the criminal activities that may tend to operate to undermine national security. These include money laundering, using an unregistered money lending business with the help of IO4 Pitso and others. Furthermore, the said Machisetsa Mofomobe is implicated in the murder of one Radiko Nalojoki. The information obtained therefrom will assist the service to counter the said unauthorized reception of classified information and any activity intended to undermine the national security of the Kingdom of Lesotho. Such information cannot be reasonably obtained by any other means except those sought herein unquote. The warrant issued in response thereto reads as follows, and I quote: "This warrant serves to authorize members of the National Security Service to 1. Seize the mobile phones of and or those found in the possession of Machisetsa Mofomobe, a Mosotho male resident at Hatetsane Maseru, with immediate effect, and 2. Conduct an investigation on such phones, mobile phones, and make copies of any information obtained therein which has a bearing on the functions of the service. 3. Retain possession of the said mobile phones for a period of 30 working days for the purpose of investigations." Thus issued on 16th May 2023, signed. It is signed, but below it is written, Honorable Minister of Defense, National Security and Environment, unquote. The second application was in the following terms. It is still a memo to the Minister of Defense, National Security and Environment, from the Director General, NSS, signed. It reads, "The above matter bears reference. I humbly request that you issue a warrant in terms of Section 26 of the National Security Service Act, number 11 of 98, herein referred to as the NSS Act, authorizing the service to seize with immediate effect the mobile phones of and or those in the possession of one Moeketsi Shale, a Mosotho male adult resident at Hatetsane in the district of Maseru. Further authorizing that upon the said seizure, the service conduct an investigation on such mobile phones and make copies of any information contained therein which has a bearing on the functions of the service. Further, that the service retain possession of such mobile phones for a period of 30 working days, for the purpose of investigations. The request is premised on credible information which implicates the involvement of the said Moeketsi Shale in criminal activity that may tend to operate to undermine national security, being the murder of Radiko Nalojoki. Furthermore, the said Moeketsi Shale is suspected of having access to classified information of the service through the help of some NSS personnel. Information obtained from the phones will assist in identifying such compromised members so that they are dealt with accordingly and the disclosure of classified material be counted against in an appropriate manner. The information obtained therefrom will assist the service to counter the said criminal activities intended to undermine the national security of the Kingdom of Lesotho. Such information cannot be reasonably obtained by any other means except those sought herein, unquote. The minister obliged by issuing the following warrant. Quote, warrant issued in terms of Section 26 of the National Security Service Act number 11 of 98. This warrant serves to authorize the members of the National Security Service to seize the mobile phones of and or those found in the possession of Moeketsi Shale, a Mosotho male resident at Hatetsane Maseru, with immediate effect. 2, conduct an investigation on such mobile phones and make copies of any information obtained therein, which has a bearing on the functions of the service. 3, retain possession of the said mobile phones for a period of 30 working days for the purpose of investigations, thus issued on this 16th day of May 2023, signed, and below is written Honorable Minister of Defense, National Security and Environment, unquote. For ease of reference, the warrants will be referred to as Warrant 1 and Warrant 2 respectively. As earlier said, the execution of Warrant 1 has by consent been suspended by order of the court. Thus, Mofomobe is still in possession of his cell phones. Warrant 2 was executed, thereby depriving Shale the possession of his cell phones. The reasons proffered for applying for issuance of the warrants and the contents of the warrants are not in dispute. What is in dispute are the following. 1, the constitutionality of the procedure for issuance under Section 26, of their issuance under Section 26. 2, their violation of applicants' privacy and freedom from arbitrary seizure of property. 3, the competence of the minister who issued them, as he is not the Prime Minister. 4, the alleged vagueness of the reasons given in the applications for their issuance. And 5, the alleged broad terms of the warrants. All these disputes call for the correct interpretation of the applications for the warrants, the terms of the warrants, Section 26, and the effect of all of these on the applicant's constitutional rights and freedom from arbitrary seizure of property. As I said, I'm not going to go into the legal analysis. I'll proceed straight to the validity of the warrants. The applicants question the authority of Minister Tau to issue the warrants and the broad terms in which they are couched. They contend that Minister Tau is the minister in the Prime Minister's office and not the Prime Minister. Absent the Prime Minister, the Deputy Prime Minister could have rather signed on his behalf. The Crown argues to the contrary, that Minister Tau is designated by the Prime Minister in terms of Section 2 of the NSS Act and was therefore competent to issue the warrants. Indeed, the section empowers the Prime Minister to designate a minister to perform the statutory functions. The word designate is defined in the Black's Law Dictionary, 6th edition, to mean, and I quote, to indicate, select, appoint, nominate, or set apart for a purpose or duty, as to designate an officer for a command, to mark out and make known, to point out, to name, indicate, unquote. The shorter Oxford English Dictionary on Historical Principles, the 3rd edition, defines designate to mean 1, to point out, indicate, to specify; 2, to point out by name or description; to name, denominate. 3, to appoint, nominate for duty or office, to destine to a purpose or fate, unquote. Since the designation is to perform important functions in the arena of safeguarding the nation's security, I consider that in context, the relevant meaning of designate is to make known by name. This accords with the constitutional imperatives of transparency and accountability. Although the Act is silent on the procedure and formality of designation, for example, whether or not this is be done in writing or by gazettement, I consider that designation is too important to be left only to the knowledge of the Prime Minister and the designated minister. It should, like other appointments of ministers to perform duties in offices of other absent ministers, be gazetted. I conceive of no reason to the contrary. There is nothing on record that constitutes tangible proof of designation. Neither the Prime Minister nor Minister Tau have filed any affidavits to throw light on the contested issue. The court is left to resolve it on the basis of the assertions of the Director General that Minister Tau has been designated to issue the warrants. Even then, the Director General does not tell us how and when he came to know about the designation. What is more telling against the Director General's claimed knowledge or awareness of the designation is that the applications for the warrants were addressed to the Prime Minister and not Minister Tau. Minister Tau signed the warrants not in the name of the Prime Minister, but in the capacity of, quote, Honorable Minister of Defense, National Security and Environment, unquote. The responsibilities of defense and environment are not covered by the NSS Act. Their reference in the capacity in which he issued the warrants casts doubt on whether there was a designation. If indeed there was a designation, he could only have signed in his capacity as the designated minister in relation to national security, because his remit would be to administer the NSS Act and no more. What then becomes of the disputed allegation of this designation? The presumption of regularity, in Latin called omnia praesumuntur rite, is an actor, would provide a favorable answer to the Crown if there was admissible evidence that Minister Tau had in the past been designated as the Minister of Defense. But neither him, the Prime Minister, nor the Director General have said anything of the sort. Absent public notice about the designation, which I consider to be an irregularity, there is no room for invoking the maxim omnia praesumuntur. I find that Minister Tau was not designated. It follows that on this ground alone, the issuance of the warrants is invalid, null and void. The application put before the minister sought information that fall in the following two categories. 1, communications between the applicants and unknown, except PITO, NSS officers that disclosed classified information or material, and 2, information implicating the applicants in crimes of murder and money laundering. Apropos warrant 1, the application for seizure and search of Mofomobe's cell phones was premised on the following 3 allegations: that he is in possession of classified information or material he received electronically from intelligence officer Pito. 2, other unknown members are suspected to have behaved like Pito, and the information obtained from the cell phones shall reveal their identities. 3, there is information in the cell phones which implicates him in crimes of murder and money laundering. The common complaint by the NSS is that Mofomobe is in receipt of classified information / material. There is no particularized level of the alleged classified information. No reason is proffered for this omission. The need to mention the level at which the information or material is classified is important in gauging the gravity and seriousness of the damage to national security. There are 3 levels of classification of information, namely top secret, secret, and confidential. Top secret is information whose unauthorized disclosure reasonably could be expected to cause exceptionally grave damage to national security. Secret is information whose unauthorized disclosure reasonably could be expected to cause serious damage. Confidential information is information whose unauthorized disclosure could reasonably be expected to cause damage. The phrase reasonably could impose an objective test. This means that in deciphering the nature of the suggested threats or damage to national security, enough should be disclosed by the NSS to enable the minister and the court on review to test the validity of the allegations. Executive decisions of what constitutes danger to national security are fact-based and political. This provides room for flexibility necessary for the minister's approach to determine whether what is said to be leaked constitutes harm to national security. The separation of powers principle dictates that courts should defer to the minister's decision. However, this is subject to the caveat that there is evidence of a real possibility of harm to national security. In reaching a decision that leaked information or material poses a danger to national security, the minister has to distinguish a danger to national security from danger to the public safety or public order. The latter are intended to address threats to individuals and maintenance of law and order by the police. The nature and level of classified information is not disclosed in the applications for the warrants. Neither is the basis of the allegations of involvement in crimes of murder and money laundering. It is only in the answering affidavit that the nature and contents of the communications between Mofomobe and Pitso are disclosed. This has been done by annexing a printout of WhatsApp messages. No effort is made in the answering affidavit to direct the court to specific messages that indicate the classified material or information and the nature of damage to national security caused by its disclosure. This is unacceptable for at least 2 reasons. Firstly, it is legally impermissible for a litigant to throw a mess of annexures to his opponent and to the court and merely invite them to read, discover, and identify the issues and their relevance. Some of the WhatsApp messages contain information which is trivial, useless, in the public domain, or even has nothing to do with national security. For example, information about debates in the upper house of parliament, the Senate, exchange of pleasantries, and suggestions of a liaison. Secondly, in law, there is no absolute non-disclosure of government secrets. Any claim of non-disclosure must be weighed against disclosure in the public interest. The point is well put by Lord Gough of Chivalry in Guardian newspapers, where he said, and I quote, "In cases concerned with government secrets, as appears from the judgments of the 2 Chief Justices, Lord Widgery CJ, in AG versus Jonathan Cape LTD, 1975, 3 All England Reports, 484 at 495, 1976 Queen's Bench, 752 at 770, and Mason CJ, then Mason J, in Commonwealth of Australia versus John Fairfax and Sons LTD, 1980, 32 Australian Law Reports, 485 at 492 to 593. The reason for this additional requirement in cases concerned with government secrets appears to be that, although in the case of private citizens, there's a public interest that confidential information should as such be protected. In the case of government secrets, the mere fact of confidentiality does not alone support such a conclusion. Because in a free society, there's a continuing public interest that the workings of government should be open to scrutiny and criticism. From this, it follows that in such cases, there must be demonstrated some other public interest, which requires that publication should be restrained, unquote. The NSS was already in possession of the WhatsApp messages when the Director General applied for Warrant 1. However, for reasons known to him, the messages were not annexed to that application for search and seizure. This, I consider, constitutes a non-disclosure of critical information relevant to the minister's consideration of whether the messages contained classified information and whether it would be necessary and a proportionate step to seize and search the cell phones. If the NSS was able to get hold of Pitso's cell phone, searched it thoroughly, and all it could find is what is in the annexed WhatsApp messages, it was a long shot for the Director General to suggest, without full disclosure of the so-called credible information, that Mofomobe was communicating with other unknown NSS members. The said credible information the suggestion of the said credible information is based on information that should have been disclosed to the minister to put in the scale in evaluating whether the disclosure sought to be searched was likely to assist substantially in discovering the identities of the unknown members. As regards Mofomobe's alleged implication in the crimes of murder and money laundering, no articulation of the basis of these serious allegations is made. The allegation is a conclusion devoid of any details of the information on which it is reached. Disclosure of the credible information to the minister would not be prejudicial to national security or injurious to public safety, as he is the proper statutory authority to whom the NSS is accountable. Without its disclosure, the minister is left to speculate about its source and credibility. There is a vast middle ground between disclosing all and disclosing nothing. In my respectful opinion, in order for the minister to properly discharge his functions, the Director General must take him in his confidence by disclosing all relevant and necessary details and sources of the so-called credible information in his possession. This will enable the minister to determine whether the information sought from the cell phones is indeed classified and likely to be of substantial value in assisting the NSS to discharge its functions, and also to be satisfied that there are no other reasonable means of obtaining it. Another factor that I consider should have been canvassed in the applications, which is relevant for consideration by the minister, is the linkage between the NSS statutory functions and investigation of criminal offenses of murder and money laundering. The Director General says the linkage is the spate code of rampant killings in the country, which threaten not only the national security and is also necessary for public safety and prevention of public disorder or crimes, unquote. This linkage is tenuous and trenches on the constitutional mandate of the police. Nothing tangible is shown that the murder of one person and money laundering threaten national security. Mr. Mushasha for the Crown submitted that it is within the competence of the NSS to investigate crimes of murder and money laundering, and for that reason, the NSS could apply for a warrant to obtain information in that regard. For this proposition, reliance was reposed in Section 36, which reads as follows, quote, "The service, Lesotho Defense Force, and Lesotho Police Force shall at all times maintain an effective liaison with the objective of fostering, preserving, and strengthening national security," unquote. The plain reading of the section is that it enjoins the three institutions to cooperate and liaise in order to strengthen national security. But this is not a license for them to transgress on each other's constitutionally and statutorily delineated mandates. The section empowers them to share information and intelligence among them with a view to enabling each to competently do what it is supposed to do. There are reporting obligations of criminal offenses to the police by the Army and the NSS. If the police have a reasonable suspicion that what is reported constitutes a criminal offense, they should trigger investigations. With regard to the application for warrant 2, the Director General stated that there was what he called credible information, which one, implicates Shale in the murder of one media person, 2, that he suspected of having access to classified information with the help of some unknown NSS personnel, and 3, the information obtained from the cell phones will assist in identifying the suspected NSS personnel. All these are bold assertions for seizing the cell phones. The grounds are shaky and speculative. Firstly, there is no disclosure of the level of the classified information and the nature of the damage to national security. Secondly, nothing is said about the grounds of the suspicion that Shale has access to classified information with the help of NSS personnel. Thirdly, the so-called credible information implicating him in the crime of murder is kept under wraps. All these are pointers to one thing and one thing only, that the application sought permission to trawl through the cell phones to see whether there is something which can be found that may link him to all the suspicions of the Director General. Without disclosure of the credible information, in quotes, possessed by the Director General, there would be no way to test its credibility other than by accepting the Director's ipse dixit. As regards the investigation of murder, the NSS application was an overreach of its statutory functions of protecting national security. Murder is a crime whose investigation is the business of the police service. To summarize, the impugned warrants to seize and search the applicant's cell phones were applied for on the basis that A, the applicants were suspected to be in possession of classified material or information supplied to them by officers of the National Security Service. B, Mofomobe suspected to be involved in crimes of murder and money laundering. And C, Shale suspected to be involved in the crime of murder. Section 26 empowers the minister to issue the warrants, but requires of him to evaluate the likelihood of the information sought in the applicant's cell phones being of substantial value in assisting the NSS to find the allegedly leaked classified material or information and involvement of the applicants in the crimes of murder and money laundering. After evaluating the likelihood of the sought information from the applicant's cell phones in assisting the investigation of the alleged crimes, the minister had to be satisfied that there were no other reasonable means open to the NSS to obtain the information sought from the cell phones. In its applications for the warrants, the NSS made bold statements that there were no other means available to obtain the information and find the officers responsible for leaking the classified information of material. The question that sticks out like a sore thumb and ought to have been answered is why the NSS could not resort to the same means it used in revealing the identity of Pitso and could not have used it to search for the identities of the other suspected members. The minister issued the warrants to seize and search the applicant's cell phones and or those found in their possession and make copies of any information contained therein, quote, which has a bearing on the functions of the service, unquote. The referenced functions of the NSS are not specified in the warrants. The authority of Minister Tau to issue the warrants was challenged on the basis that he's not the Prime Minister or designated by him to perform the statutory function laid down in Section 26. Neither the Prime Minister nor Minister Tau filed any affidavits in these proceedings. It was left to the Director General of the NSS to pick up the cudgels on their behalf. The judgment holds, therefore, 1, Section 26 of the NSS Act authorizes issuance of executive warrants to interfere with the applicant's rights to informational privacy and freedom from arbitrary seizure of their cell phones. 2, the procedure outlined therein requires that the applications for warrants and their issuance to meet the thresholds of information sought being of substantial value in the investigation of the alleged crimes, and there be no other means of obtaining the information. 3, there are no safeguards to guard against abuse of the power to issue the warrants. This being a process presided over by a minister without external independent supervision, the procedure of issuance of warrants under Section 22 lacks the necessary safeguards to provide adequate and effective guarantees against arbitrariness and the risk of abuse. For this reason, the Section 26(2) procedure is declared unconstitutional. 4, Minister Tau was not designated to perform the Section 26 statutory functions. He therefore lacked authority to issue the warrants. 5, the warrants did not tell the applicants what offenses they are suspected to have committed as to authorize seizure and search of their cell phones. They only got to know them when the Crown filed its opposition to their applications for relief in court. It emerged from the Crown's papers that they are suspects in crimes of possession of classified information, murder, and laundering. 6, the crimes of murder and money laundering are not national security offenses. Their investigation is outside the constitutional mandate of the NSS. Furthermore, seizure and search of property of persons suspected of committing these offenses is by judicially authorized warrants in terms of Section 46 of the Criminal Procedure and Evidence Act, number 7 of 81, and Part 4, Division 4 of the Money Laundering and Process of Crime Act, number 4 of 2008. 7, the crime of possession of classified material or information by persons who are not members of the NSS is found nowhere in the NSS Act. What is found under Section 39B is persuading a member to omit to carry out his duty or to do any act in conflict with his duty. This is understandably so because, unlike members, non-members have no lifelong secrecy obligations. In the result, the following orders are made. In constitutional case number 007/2023, the application is granted. 1, the application is granted. 2, it is declared that Section 26(2) of the National Security Service Act number 11 of 1998 is unconstitutional. B, the warrant to seize and search the applicant's cell phones and or those in his possession violates his right to privacy and freedom from arbitrary seizure of property and is hereby declared unconstitutional. C, there be no order as to costs as none were sought. In regard to constitutional case number 0009/2023, the following order is issued. 1, the application is granted with costs. 2, it is declared that Section 26(2) of the National Security Service Act number 11 of 1998 is unconstitutional. B, the warrant to seize and search the applicant's cell phones and all those in his possession violates his right to privacy and freedom from arbitrary seizure of property and is hereby declared unconstitutional. 3, the Director General of the National Security Service is directed, A, to return forthwith the applicant's cell phones, and B, to delete all the information copied from the cell phones. This judgment is concurred in my two brother and sister judges. our machines are afflicted by a virus cancel, so we cannot give you electronic versions of the judgment. But what you can do is to just wait for this judgment to be copied. I'll make how many? 3 copies. Yeah. It will not take an ordinary long time. The court adjourns.
Music bin.
O lokela ipotsa nda hore na hobane ditonakgolo tsohle tse bileng le Lesotho di so sebedise molao ona. Ntate Majoro ha so sebedise, Ntate Thabane ha so sebedise, Ntate Mosisili ha so sebedise, Ntate Ntsumokgetla ha so sebedise. Ke nahana ke ka lebaka la ho utlwisisa tsamaiso ya puso hore ditokelo tsa motho di tinkeletswe ka hara molao wa motheo. Ba iphilela motho fela wa mo kontraka ya sa utlwisising hore na ditokelo tsa motho na ke ntho kgolo haka o tsamaya saena diwarete tsa mofuta ona.
Dipampiring tsa lekgotla tseo NSS ne di kentse ka mona hara tse ding e ne se yo e bontshitse ha yo belella ka ditaba tsa mane laundering le polao ya leqhashasha. Na re ka bona o nka dikgato mohlomong civil case from now.
O jalo nna ntse re le ka mona re fumane hore mapolesa a etse press conference mme ba bolaing ba belaellang ba ga diponelo ha hona moetetsi shala ha hona matsholo a mfamo. Mme sena se bolela hore re a pele le NSS makwetha a rona sa ntse a sebetsa taba ena by Monday re tla re faetse nyewe ya defamation ka ya tshenyo le ditso ke sa ya hole le mo kontraka ena re tla etsa ga utlwisisa rona taba tsa puso di tsamaiswa ka tsela e
Adeshale
Dadi. Anta ala gabela, o ba ta ki gabela nna ba.
ba yo tsotsi ba la bonza
O anta nte ki tnei di bua nnete. O anta ki tnei.
emela ka ntena he o tso utlwa ntena
Ana ki tinno ki ntwe lo ngata ka ndwa yo matala lo mokaka. Jwale o sitwa lo hore ba o tlwaela hampe. Ba jwale ba ba ho. Fela ki tnei. Ka nna tu bua le sha. Wa tsa ki motho mong a ratang dipolitiki tsa kgotso di bua mehla. Tsa kgotso tsa lerato tsa ntlafalo matlafalo ya batho. Ha ke pelo ya ka sa mo heteng. So motho a moholo ha a ntwala mpe ke a ntshe a mpe fe. O so kana ana o tsamaya ka ntwe o la risitswe setoko sa motho. Jwale o sena le solo le o ka tang o phela o le mong. Ona le motho a bola uwe. A neng a rata ka batho ba bana. Hampe bile le motho eo e ne le ntwe ka metswalle. Jwale motho o moholo bona ke je gitseng tena ya ntse ba advice entse pelo ha ho empa ke na dumela go dia bolosi eno a senya pelo mo dimong philong ke ba etsa ke ba file di phone a master le ke ba file delivery yana ke a pheta apa tsa matekane le mmitse lona ba ngwana nka mo fa di phone tsa ka 100 times is 100 fela ke ja ka fana ka tsa hae motsotso tsa hae le nthati fe motsotso fela phone tsa ka fana ka
malapa
ka tso
o tla ba ditsi jwa
a di kwana ha ke ta o bolawa totobe ke eno mono e mo etapela bitsang tata gwane ya thabo simo le ara I matara go wela di clip useng go motho bola o ima congress potsa go gona ndwentse batho ba potlakela ho le lahla ka mmele lona ba sotho ka pola ya qhashasha ke efe a ene ba NSS ena ina le kelelo le lokela ke batla fono tsa malebale tsa matekane le tsa qhashasha
tsa yunibetsana
inunubetsa bana ba lokela ba ke ba shebe di fono tsa batho ba bona ndo kopanyang batho ba le motho yo ine le inna le qhashasha ona kopangwa ke eng le matekane le malebale ke ba file difono tsa ka ba tlile go tla mo ba nkile melaetsana le matšhisetsa mana bua le NSS le leo ile motswallo wa hae jwalo ka ha o boletse ke ba file phone ha bana print out le communication le ha ile le nngwe fela bo mmele bonta one fo ya o fela shane o le tseditse le NSS nyeo ka date 18 bana le tsona di phone tsa ha ona molaetsa le o le mong mo ba re le NSS ke le na le itetse we me ha dutela di etsala ha o lo lona bembaka a mo di moholo le lokela nka ho bona boikarabelo bo le bojerene le lekgotla la DC tlo molona lena la mokga wa BNP bona ha e etsala ho ordinary people what happens ya re ke pheta ha bela tsindi ha ke tshusu ke motho a ntseng a media politiking ho ha I'm not scared, I'm not shaking. Ho nna ntwe na wa se wake up call o ke le motshana ha ena le Lesotho ke je re boikarabello ba ho lwanela toka ha holo batho ba ordinary na ha ena le dikolo tse ngata o ke ipotsa gona ana tjena go matekano sa ke re ile mesebetsi e mekae ka o nka fono tsa sha o create le mesebetsi e mekae ka o le lekisa machisetsa matekano a ke tsebe gona le gona le tlompotsa eng wa mona ma itemana ke nyeketso fe I don't even know what to say because it's ali bupetsana fela ke sa tsebe gona hantle ke tlo bua ebe ke tlo reng mo batho ba ke utlwa hanga ka bua mo motho mo ke tla ipakela le mathata ke ngwana modimo fela wa motho a itulela malaeneng a senanta so really le ana ba le ke ntse ke tsitsipano bana ha ke tsebe gona batho ba ileng ba jutsa go ke ba ile le khashasha na ba sa ba tsebile hore matekano o tseba tsa tsinyela gona ke bo mang batho ba ntse ntho e
Shale apology ya motho a ka batla ho tseba gona ha ile mo difono tsa go se di khutsetso wena ha ona le tsona
a tso go bona ka ta kopana le bona le agente ya ka ke bona gona fono tsa gantse di boemong bo ke ba fileng tsona and unfortunately ha ke sa tla di sebedisa ke re fono tso ba sebetsa matekano le batho ba ba haeba o ka se isa fono ileng ya dila fono ya matekano a je motho a isa an opponent ya dipolitiki ibile ke nna e teng ha qala party ha ke ta o thea party ka mo o etsa hore hantle ntho mo tsang dipolitiki gore batho ba ntse ba mo fa dintho tse sa le ba mo fa tsona ditswao tsela tse be ke mo ruya mo kala le Lesotho ha ba tshale o batla o tla ikukela ka bitsa ntho ya generational war hore batho ba dile mo tsa rona e sale ke hana tsena ho tloa ka yena wa tswa ka bo menthumeng bo motho ke mang bo mme matanyana bo ntate se ga can name them all if na ha ena e mona mo eteng these are the very same people ha ba o thwe jolo ka go to ba etsa di central ha twa di tender ka tsinya tshele ha e bana ha ena sale sinyelo these are the people le sale ba senyetsa na maqhekwana ana tshwereng matla a puso so really ntwena I don't know ke a tseba le hore ba ntse ba hopola hore ka nna ba hona ntse ke di bua le ma parliament ya bo hey na re matekana tseba ntwena la uka se ke ntate ke theothile ba ha ke na o emisa ha eba ha tshwere matla a puso wa sebedisa hampe ke la ka bua ka kamano ya ha ile sesole le mapolesa a ga ke la informa ka la fika dipolitiki ga re ntwe e kotsi ka bua ka taba ya IEC mo la ntwe ra e kotsi ga ba ntse o ke bita ya ba kere there is no way motho wa morui a makana kana ka tloa mane a go tla dipolitiki ba nathetse batho go tsamaya go itsa ha ka ntwe ena ya motho ena e kotsi na henya go at least ke a tseba hore ke ne ke se bita no to ke lahlela ke mosebetsi ke jwetsa batho metlaela ke holetse lapeng la bofutana ha o tlo ntshosa ka tlala ke right ibile ona motla ke tshoswa gore e feletswe ke mosebetsi ha ke monna seleo ha ke a tseba ho iphatela gona ke phela jwa ndwena ba yentseng o le ka go o emisa sha le motho a bitsa matekana batho ba modimo jwetseng gore ha se re tibile ntja tse thata haholo Lesotho mo yena ka nnete the last man to worry about matekane is the last man to worry about politiki tsa Lesotho bo motse bana ba holo bo thoma thabane ntja tse thata bo mnyane mo ka ntse ha ke era a se motho a ntsosa o le hanyane kana mme ana tsena ke a tlo ke itle ke o ikap call lona batho ba eso ba di politiki le bona this was just a wake up call kana bana se re phomotse a holo bana batho ba itatela nna lona ba tla le ba itaba ke iphumuletse a ga di qothela morowa wa ntho wa khela la pemma it just came to me mama ha ya ka tsa mokete ke tla hape he batsi jwale ke tlo etsa mosebetsi o ke lokelang ho etsa wa dipolitiki ho tloha jwale ke ne ke sitwa ho bua ba bang ba hantse ke thotse ba sa he jwale ha bue hobane ho itswile ha ke a tshoha letho haholo lona batho ba Eswatini hai
o lebile ntate
Thank you, Mofomobe.
Music bed.
we are